Hi, I'm Sandy Levin, Executive Director at LA Law Library, and I'd like to welcome you to our presentation. Before we start, I wanted to say a few words about the Law Library. Even though our physical locations are closed to the public due to COVID-19, we've been working hard to continue making all of our essential services available remotely. We're available 6 days a week via phone, email, and live chat to help you find information and resources for any legal question. Items from our enormous collection can be scanned and downloaded and sent to you at no cost during COVID-19, whether a case, a section from a practice guide or self-help book, a legal form, or anything else you may need. You can also continue to attend our popular classes we offer at the library by signing up for our free online classes through our website. We have over 30 classes on representing yourself in court, dealing with common legal issues, legal protections for tenants and employees during COVID, and much more. Our volunteer lawyers at Lawyers in the Library continue to do their good work helping those who can't afford legal representation. Simply go to our website and click the link for the form to sign up, and we'll arrange for a telephone consultation with one of our volunteer attorneys. So when this class is over, go to our website, www.lalawlibrary.org, sign up for our email list, follow us on social media, and check out all the great resources available. Thank you and enjoy.
On behalf of LA Law Library, I'd like to welcome you to today's program, Student Debt Relief, COVID Updates. Today's presenters are Robin Smith and Josephine Lee from the Legal Aid Foundation of Los Angeles. Welcome, Josie. Welcome, Robin.
Thank you.
Thank you. Thank you very much to the LA Law Library, and thank you for everyone who's joined for today's presentation. We'll be discussing the important updates and considerations for student loan borrowers under the CARES Act and other COVID-19 related relief options for student debt. Next slide. For anyone who's experiencing their own student loan issues or maybe assisting student loan borrowers in their practice. Next slide. To provide an overview of today's webinar, we will be providing a summary of the CARES Act. By now, probably anyone who has been doing this kind of work is familiar with the CARES Act. It covers a variety of issues, but we'll be focusing on the provisions that deal with higher education and student debt relief. I'll also be discussing California-specific updates for borrowers and for consumers. And then we'll be moving into some considerations as we anticipate a lot of schools will be reducing their capacity or maybe facing closure. And Robin will be discussing some things to consider if you or a client or a student borrower is facing school closure, and we'll reserve some time at the end to address your questions. However, I encourage you to input your questions in the chat function. As was mentioned earlier, all participants are muted for this presentation, but if you would like to have bring up any questions, please put them in the chat, and Robin will be taking a close look at monitoring the questions, and so we may be taking some throughout the presentation. Next slide. So before we start, we wanted to take a couple polling questions to get a better sense of who is joining us today. So if you can please let us know who you are. A poll should be popping up right before you, and so we'll leave some time for folks to complete that poll. Great. So hopefully everyone has had a chance to submit the poll. we encourage you to do so. This gives us a better sense of who is joining us today, and so we can better tailor our presentations in the future. We do have a second poll for folks to also understand how familiar you are with this kind of work. So the poll should again pop up in front of you. If you can please just take a few seconds to complete that and submit your responses. I'm so sorry about that. My computer just died, but I hope that wasn't too long of a delay. So we'll be moving forward. Next slide. Wonderful. So as an overview, the CARES Act, also known as the Coronavirus Aid, Relief, and Economic Security Act, was emergency legislation that was passed by the federal government in order to meet the urgent public health crisis in the face of coronavirus pandemic. It was signed into law at the end of March, a couple weeks after the president declared that this was a national emergency. And there are a variety of different provisions that tackle different issues. As I mentioned earlier, we'll be focusing on the higher education and student loan related provisions. But for anyone who is interested, you can find the full text at the link provided. Next slide. It is very important to note from the onset that not all federal student loans are covered by the CARES Act. It is also important to note that private student loans are not covered. So the covered loans, and this will be the bulk of what I'll be talking about today, are direct loans, meaning they are directly currently owned by the Department of Education. They're held by the department, and also certain federal family education program loans, or FEL loans, that are also currently held by the department. The loans that are not covered are commercially held FEL loans. So the FEL program, it's no longer in use. All federal student loans are direct loans after July of 2010, but some of the older federal student loans that were dispersed were under the FEL program. Some of them are held by the department and some of them are commercially held. And so I'll be talking about in the following slide how you can determine what type of federal loan you have, but it is important to note that commercially held FEL loans are unfortunately currently not covered by the CARES Act provisions. Perkins Loans, these are federal student loans that are held by the schools. The Perkins loan ended at the end of September of 2017. So anyone who's a more recent borrower probably doesn't have a Perkins loan, but those are also loans that are not covered under the CARES Act provisions. And then finally, as I mentioned earlier, private student loans. These are separate from federal student loans. They are usually dispersed by a bank or some other third-party institution, sometimes even the schools. And these also are not covered by the provisions that I'll be talking about today. This is definitely a gap, and many advocates as well as legislators have raised this issue that the CARES Act is not addressing and providing immediate relief for around 9 million federal student loan borrowers. However, at this time, there are no concrete changes that we can assure borrowers that they'll be entitled to this. So hopefully this information will still be helpful for those who have loans that are covered, and there are voluntary options for folks who are not covered. Next slide. So how do you determine what type of loan you have? Typically what happens when I get a student loan client, they'll come in and say, I have student loans, but they're not exactly sure what type, even between federal and private. And that's very common because this is kind of a complex area, and determining what type of loan you have can be difficult. The easiest way though is to check studentaid.gov. That's going to be your main portal to figure out all of the federal student loans under your name. The account, you're going to need a federal student aid ID. and a password, which you can create if you have an email address. And once you have that information, you can find out all of your federal student loan information. The website, I do have to admit, is a bit difficult to read, but another option you have is to contact federal student aid at 1-800-4FED-AID. And so you can get that information as well. The last option is to contact your servicer. So folks who already have their own student loans may be familiar with their servicer. This is the company that contacts you, that usually sends you your monthly billing statements, and is often the middleman between the Department of Education or whoever your loan holder is. And so some familiar names may be Navient, Nelnet, Mohila, Fed Loan Servicing, Great Lakes. Those are some of the major federal student loan servicers that are out there. So you can also contact them to ask if your loans are covered. Next slide. So what kind of relief is available for covered federal student loans under the CARES Act? The first and most important and provides probably the greatest relief for borrowers is the payment suspension. So from March 13th to September 30th of this year, your payments will be automatically suspended, meaning no payments will be due. You won't be considered late on the payments. It will be considered an on-time payment, even if no payments are made. And so even auto-debited payments for a lot of borrowers who may have set up some kind of auto payment monthly system, those will also be automatically suspended. Borrowers who are covered under the CARES Act should have already been alerted by their servicer this is happening, but in case your contact information wasn't updated or perhaps you missed that notice, again, as I mentioned earlier, you can find out on your own if your loan is covered by checking your student aid report or contacting your servicer. Next slide. For some folks, the suspension will still count towards eligible income or loan forgiveness or loan rehabilitation programs. So it will make more sense in the next slide, what I mean. So can we go to the next slide? So there are certain types of programs where you have to be making what's considered on-time monthly payments in order to qualify for loan forgiveness or in order to get your loans out of default. During the payment suspension period under the CARES Act, even though you are not affirmatively making any payments, the months that were paused under the CARES Act will still count as if you did make a payment. So for example, under IncomeDriven Repayment, which is a program that allows borrowers to pay their monthly student loan payments according to their income instead of the loan balance, this is often what we really encourage our clients to seek to ensure that they have the most affordable payment options. So if you're on an income-driven repayment plan, you pay according to your income. Typically, the plans last for 240 to 300 months or 20 to 25 years. If there is a balance left over at the end of that time, then the amount is forgiven, although there are tax consequences. It's a very long-term program. But basically under the CARES Act, even though no affirmative payments have been made, even when maybe you had like a $25 payment due under income driven, those payments will be zero during the payment suspension, but they will still count as if you made a payment to qualify for the eventual loan forgiveness way down the line for income driven repayment. It is important to note that once this suspension period is over at the end of September, whatever payment plan you are on, whether it was income driven or a standard repayment plan, will start up again. So if folks have experienced any significant reduction in their income, I would encourage you to contact your servicer and to try to update your income information and to get on an income driven repayment plan if you are not already on one, to ensure that once payments start, you're not going to be overwhelmed with a huge monthly bill. For folks who are currently on an income-driven repayment plan and are familiar with the process, there is an annual recertification requirement, meaning once a year, you have to provide your income information to your servicer so they know to update what your monthly payments will be for the next 12 months. During this CARES Act suspension period time, that annual recertification date will be deferred or delayed for 6 months. So please note that and communicate with your servicer if you're not sure exactly when that will be for you. It is very important for folks to make sure that they submit their paperwork by their annual recertification date, because if you do not do so, then you'll be taken off the income-driven repayment plan that you're on, and any interest that accrued during that time can be capitalized, meaning it's added to your principal balance. So it's very important for folks to keep a lookout for that. That's really where we see a lot of folks fall off of the income-driven repayment plan, unfortunately.
So I have a couple questions for you.
Sure.
One is, can you switch over to the income-driven repayment plan today and have the suspension counted towards 10 years of public service loan forgiveness?
Okay, so that's kind of a twofer. So
Yeah.
you can apply for income-driven repayment right now. That application may be delayed, though, I just have to say, because servicers, we are seeing some delays in the document processing time. But you can apply now, and say if it's approved at the end of August, so that September month will, and if your loans are covered under the CARES Act, yes, you will be, that 1 month payment that's still covered under the CARES Act will count for income-driven purposes. However, it is important to note that we have around, we're in July, we have around 2.5 months left under the CARES Act. And so I don't know if you'll be able to reap the full benefits of that payment suspension. Income-driven repayment for public service loan forgiveness, or PSLF purposes, that's really the plan you want to be on if you're going to be seeking PSLF. However, once you switch over to IDR or any kind of IDR plan, the moment that you start that plan is going to start the time for the 120 qualifying payments or PSLF. So I hope that answers your question.
And also just to clarify, a reminder, it's only for direct loans. If you have FFEL loans, you cannot qualify for public service loan forgiveness.
That's a really important point. That's correct. And so if you don't know what type of loan you have, you can go to the student aid website. And basically, if you don't have loans that qualify, say you have all FFEL loans or a FFEL consolidation loan, and it's not covered, so it's not going to qualify for public service loan forgiveness, you can consolidate into a direct consolidation loan. And then from after that, choose to pay on an income-driven repayment plan, and those payments will then moving forward count. I know it's really complicated, and unfortunately, there's no real look-back period for our FFEL borrowers right now for PSLF, but I hope that information is helpful.
And again, another question is, are payments required to be kept up during the CARES Act to be counted towards the 120 months for PSLF?
No, so that's my next point. So time and suspension, even if you have loans that are covered by the CARES Act and direct loans, because like Robin mentioned, they have to be direct loans to be qualifying for PSLF. Yes, those pause payments from March to September, even though 0 payments are being made, you're covered. So those payments are going to count as if you made a payment for PSLF purposes. There's actually an important caution here for folks who were trying to make payments ahead of time, or maybe making payments because which I'll talk about later, there's 0 interest right now on covered loans. You do not want to be on a paid ahead status for your federal student loans, because those months may not count towards PSLF. And so it's really important to communicate that to your servicer. The best way, I know it seems kind of strange to just trust that these payments will count, because there's been so much misinformation about PSLF, but there has been a lot of department publications assuring borrowers that these months are going to still count towards PSLF. I hope that helps. And the final is rehabilitation. So rehabilitation is one of the 2 pretty main strategies to get your loans out of default. So this really only applies to borrowers who have defaulted federal student loans. The rehabilitation process takes 9 to 10 months of making on-time monthly payments in order to get your loans out of default. So months that would have counted, or I'm sorry, payments are suspended for rehabilitated loans that are covered under the CARES Act. And so even though you're not making that on-time monthly payment, your payments are suspended and it'll still count as if you were making those payments. So you could technically get out of rehabilitation by making those no payments if your loans are covered. Please note though, for all of these options, payments will start to be due again after September 30th. So even if you qualify for these various suspensions, you do want to start preparing because the deadline is coming up and it will probably come sooner than you think, to know and be ready for what your payments will look like after the suspension period is over. Next slide. So interest waiver. In addition to the payment suspension, all federal loans covered under the CARES Act are subject to a 0% interest. This is really helpful because it's basically saying, look, not only are you not going to be having payments due, your balance isn't going to be increasing during this time, because that's what really hurts borrowers is the interest accruing. There are options to put your loans on pause payments, even outside of the
We lost Josie there. Look, Josie, we can't hear you. Oh, there you go.
Sorry, was my internet? Okay, great. I just want to note too that the 0% interest also applies to loans that are in a grace period and in default. So for borrowers who are currently in school, your loans are probably in a grace period. And so this is really helpful if you have unsubsidized loans and you're worried, well, I don't know if I'm covered by this. The 0% interest is still going to apply to you, even if the payment suspension does not have a real any impact on you right now because you're in a grace period anyways. Next slide. Great. So in addition to the payment suspension and the interest waiver, it's important to note that the CARES Act ensures that for credit reporting purposes, any payments that have been suspended will be treated as if you made the regular payment. However, we do caution folks to check this. You can check your credit report for free as a consumer from each of the major credit reporting bureaus, TransUnion, Equifax, and Experian. You have a right to check all of them once every 12 months at annualcreditreport.com. That is usually what we always encourage our clients to go to. You can get like a PDF version of that. And so it's important to just do as an informed consumer once a year. I don't really enjoy doing it because if there are errors, it's very difficult to try to get it fixed, but it's better to be informed and to know what's happening on your credit report. Next slide. So for folks who have defaulted federal student loans, they are subject to a wide variety of very strong collection powers. Please note this is a government debt. So in just the regular scheme of things, if you have a defaulted federal student loan, you can have your taxes offset, you can have your wages garnished, you can have your Social Security benefits offset, except for SSI that is exempt. You may be subject to a collection lawsuit. It's going to affect your credit. You're going to be subject to pretty high default fine and fees. However, if your loan is covered under the CARES Act and you are in default, any type of involuntary collection is suspended. So that includes the government benefit offsets, the tax refunds, and the wage garnishments. This period, it covers the period from March 13th to September 30th. However, for some of my clients who filed their taxes earlier, say in early March, in February, and they had their taxes offset, so they weren't yet, the CARES Act was not yet in effect, they've been able to contact their servicers to get that money back. They don't necessarily have a right to do so, but I encourage you, if you are seeing any clients or you have seen anyone who's experienced this kind of involuntary collection and they're covered by the CARES Act, a lot of servicers are willing to work with and refund that money for this time. Again, this is only a right for folks whose federal loans are covered under the CARES Act. But if you have a commercially held FFEL loan, you may be able to negotiate with the servicer to get that money back as well. I just want to note at the bottom here, there are issues that we've seen, particularly with wage garnishments. There's a lawsuit that was filed at this point, it was several months ago. But part of the issue is that the department notifies the employers to lift the wage garnishment to collect on the defaulted federal student loans, but it's up to the individual employer to effectuate that garnishment order lift. And there are some breaks in that chain. And so there was a lawsuit filed. So if you are seeing any of these issues, we encourage you can contact our office and we can evaluate and see if it's something that we may be able to assist the borrower with. Next slide. So this is just kind of a out there information. If you are seeing any of this, involuntary collection, including any portion of the stimulus payment, the economic impact payment that was taken to collect on a federal student loan or other debt, this may have been an illegal debt collection. And so if you're not sure and you need help evaluating, please contact our office, and that information is there. Also in the earlier slides, which I think should be made available, I have included my personal email as well as Robin's email if you want to contact us. Slide. Next slide. Thank you. So the Perkins Loan Program is not covered by the CARES Act, as I mentioned earlier. However, there are some provisions for relief for ed-held or department-held Perkins loan. They're eligible for a 60-day forbearance, meaning a pause on payments and zero interest for the entire March to September period. However, most Perkins loans are held by the institution. Usually it's going to be your school. And so that's going to be on a case-by-case basis for the school to voluntarily decide to apply any of the zero interest or payment suspension. They are not required to do so. But the best way is to communicate with the school and to try to get those same kinds of benefits applied to your institution-held Perkins loans. Next slide. And just in line with that, again, the rights to these CARES Act provisions for the payment suspension, zero interest, the pause on involuntary collection, all of that only applies to direct loans and department-held FFEL loans. So all other loans, including commercially held FFEL, are unfortunately not going to have borrowers are not going to have a right to this. However, they can request it, right? There are some servicers, a lot of the servicers who deal with both commercially held FFEL and department held FFEL, they may be the same servicers, and so they may be familiar with the provisions and may be willing to extend them to your loans. But it's a matter, again, a case-by-case basis and borrowers affirmatively requesting them, as opposed to the loans that are covered by the CARES Act. Those are all automatically granted. So you can request the various provisions that I've listed on the slide here. And again, I encourage you to contact your servicer to ask that these relief options be provided. Next slide. This, so if you are feeling like you would really benefit from this, it kind of goes to what I think the earlier question that I received, but you can consolidate your commercially held FFEL and Perkins loans that are not owned by the department if you want to try to get some of these benefits. This made sense earlier on, maybe in like April, May, because the consolidation process can take maybe 2 to 3 months. And so you would still have some time left over before the September 30th deadline ran. However, at this point, I'm not I can't say whether your consolidation will be completed before the September 30th deadline will come up. And so it may not be the best option, but for borrowers who are trying to seek PSLF and they have commercially held FEL or FEL loans and Perkins loans, they can try to consider this option so that they can get the income-driven repayment plan and to eventually qualify for PSLF. I just want to note though, any income-based repayment plans that you made on a FEL loan or Perkins loan prior to consolidation, the clock is going to start again for income-driven repayment plan loan forgiveness purposes. So say you were making planned payments for 5 years on IBR, so you already put in 5 out of the 20 years that could have counted towards eventual loan forgiveness. If you consolidate, the clock starts again. So those are just some things to consider. It is very complex, and it does require just an individual analysis of what's best for your particular situation. Next slide. So there are some updates. The department has regularly updated their FAQ at this link, and they do note if something is new or updated so that you can see kind of what the most recent interpretation or expansion or a reinterpretation of what the provisions mean. And so I encourage you to go there for updates, and hopefully they will continue to update that. And if there are any changes to the law or any, like a second bill that goes out, then you can probably find updates there as well. Next slide. So I just have a few slides about the California specific updates. There are most of what I talked about before, that was all federal legislation under the CARES Act and applied to federal student loans. In the state of California, there are some additional protections for borrowers. So although private student loans and commercially held FEL are not covered under the CARES Act, the Governor Newsom and the Department of Business Oversight in California were able to negotiate an agreement with many of the private student loan commercial FEL servicers to ensure that there was some kind of relief, at least a 90-day forbearance, and including no late fees, fines, or negative credit reporting during this time. And so you can see if your servicer was covered by that kind of settlement or negotiation at the link that is provided on this slide. Also, if you are trying to negotiate with your FEL servicer or a private student loan holder to negotiate some kind of relief during this time, and they are refusing to do so, while you don't have a right under any law, you can still file a complaint with the Department of Business Oversight and hopefully get some help in negotiating some kind of relief options for you. Next slide. There was also a state executive order that prohibited most judgment creditors from garnishing any COVID-19 related financial assistance. The wording was very broad, so that includes the economic impact payments, but it does not stop garnishments for child support, spousal support, or victim restitution. And so if you have, as I mentioned in a prior slide, if you are seeing anyone who's experiencing offset of their economic impact payments, AKA the stimulus check, because of a defaulted debt or a defaulted student debt or some kind of judgment in California, that might be a violation of this executive order. So we just encourage you, again, our phone number and our website is listed here. Next slide. So particularly for students, the CARES Act provided a large sum of money for schools, and it ordered schools to pay at least 50% of that relief directly to financially distressed students. The link that we provided shows you how much that your school received, and there's a lot of flexibility in how schools can administer these funds. Importantly, however, there are a few lawsuits, one by Washington colleges and universities and one by the California community colleges, because of the department's recent announcement that these relief funds were only intended for students who are eligible for federal financial aid. So that excludes undocumented students, it excludes DACA recipients, and a whole host of other students who are not eligible for financial aid. In the Washington lawsuit and the California Community College lawsuit, federal judge did approve a preliminary injunction in both lawsuits, but they are very narrow in scope. They only pertain to the plaintiffs in those cases. And so we'll see what happens, but that's kind of the current state, just to let people know who are interested in this issue, that there are lawsuits happening to ensure that all students are able to get some relief covered under the CARES Act. Next slide. So typically, students who are working while they're in school are not eligible for unemployment benefits. One of the reasons being that if you are working full time, it's considered that you're not available for work. Also, oftentimes students who are working are not earning the minimum amount to qualify for UIB or unemployment insurance benefits. However, under the Pandemic Unemployment Assistance or PUA, it's greatly expanded the eligibility so that many students who work may be eligible for some kind of unemployment assistance. So this is going to be really helpful for students who need that extra financial help during this time. Next slide. If you know a student, or if you are a student who withdrew during your program due to or as a result of the coronavirus crisis, you can request to have your direct loans canceled for that pay period. So typically when you take out a federal student loan, it's going to be for a certain loan period. Usually it follows like the semester or the quarter of whatever your school goes by. So if you were unable to complete and you withdrew, you can request to have those loans canceled. The next part, which Robin will talk more about, is separate. If your school closes within 120 days of your withdrawal, or it closes while you were still enrolled, you have rights to have your federal financial aid canceled. And so what happens when your school closes? What are some things to think about? How do you prepare? Or if you are seeing schools closing, around you, or seeing borrowers who are facing this issue, there are a lot of things to consider. And so Robin will be talking about that section, how best to help borrowers who are facing school closure. So I'll turn it over to you, Robin.
Sure. Hi, everybody. Yes. So as Josie said, if your school closes within 120 days after you withdraw, then you are eligible for a closed school discharge. However, I know that a lot of people during this time aren't sure what's going to happen. Whether or not your school will close is unclear at this point. And so I know a lot of people are nervous and want to know what their rights are. Can we go to the next slide? So for a school to be eligible for a closed school discharge, your school actually has to close. So that means your whole campus, your physical campus has to close. If you're an online student only, then your online school has to close. So if they just stop offering your program, for example, that is not considered a school closure. When a school closes, the Department of Education will come up with an official school closure date. That's the date from which the 120 days withdrawal period starts to count. You are also eligible for a closed school discharge if you're enrolled on the date that the school closes and you can't complete because the school closes, or you're on an approved leave of absence when the school closes. You are, if that happens, both eligible for the discharge of your federal student loans, as well as any Perkins grants. So that means your Perkins grant eligibility will be restored. We do have a flyer that explains this, and I'm not sure if you all got a copy of that. If not, we will figure out a way to email that information to you. Or actually, Josie, can you post the website that the flyer is at while we're online? That'd be great. Okay. This is further complicated by teach outs and credit transfers. So if your school closes and you transfer a credit to the same program at a different school or a comparable program, if you finish that program at that school, you will not be eligible for a discharge. Similarly, if you participate in a teach out, which is a program offered by a different school, but it was arranged by agreement with the closing school so that you can continue there and they accept all of your credits, that also you are not eligible if you complete that program. It's very complicated. Take a look at our flyer if you have questions. Now, one question says, if the school closes a year after you attended, do you still qualify? No. The only way to qualify is if you withdrew within 120 days prior to the date of closure, or you were in attendance or on an approved leave of absence when the school closed. Now, the good news for people in California is some of you, if your school closes, I know many of you probably have gotten private student loans, or you've gotten GI Bill funds to pay for your school, or you've had other sources of funding. If your school is approved by the Bureau for Private Post-Secondary Education, then you are also possibly eligible for payment of those private student loans or reimbursement of the GI Bill funds as a future educational credit. You can apply for that, but the only people that are eligible are for schools that are approved by the Bureau, because they pay into what's called the Student Tuition Recovery Fund. This is primarily for profit schools. It does not apply to public schools, also does not apply to quite a few private nonprofits, because that's how the law is in California. In addition, if your program is discharged, right? So we don't know if a lot of programs may be discontinued before people can finish their programs, meaning your program is stopped, but your school stays open. If that happens, you're not eligible for a federal closed school discharge. However, if your school is approved by the Bureau, you are eligible for Student Tuition Recovery Fund relief, including for the discharge of your federal loans through the Student Tuition Recovery Fund. Go to the next slide. So I know, as I said earlier, that a lot of you are in limbo right now. You don't know what's going to happen with your programs. You don't know if they're going to be offered online. Some people have clock hour programs. Those are programs where you have to learn equipment or in-person skills from other professionals. And so online education may not be a good route for you. So here's how you protect yourself. First of all, it's really important for you to document what is going on at your school and to keep key documents that you will need to prepare for either a school closure or the closure of a program. That means if you have an enrollment agreement, make sure you get a copy of it. These are, again, primarily for-profit school students. You sign an enrollment agreement when you enroll at a school that has all the terms of what you agree to. The second thing you need to get from your schools, and this is for all schools, is a record of all the financial aid that you received and that was paid to the school, as well as all the amounts that they've charged you. Usually this document is called a student ledger, and it's like an accounting of all of the money that's paid on your behalf and then all of the charges that the school applies that money to. Keep track of the dates that classes are suspended, get your attendance records, and if you withdraw, make sure you withdraw in writing according to the terms of your enrollment agreement or your school catalog, and keep a copy of whatever you submit to withdraw. Very important, because if you don't, withdraw in writing and keep proof that you've done so and comply with the school requirements for withdrawal, you may still be on the hook for tuition owed to that school, and you may not be able to get a refund for the portion you didn't attend. Finally, keep a copy of all school communications, any emails, texts, notices sent to you about program suspension, promises that they will finish your program at a later date, school closures. All of that is really, really important to keep, because again, if something happens, you may need to prove your eligibility for some kind of student loan relief later on. And the only way to do that often is you documenting and keeping documents. It's also important to get these documents now, because when schools close, they often don't maintain the documents, and the documents are destroyed or they're lost. So again, very important for people to get these documents now. You should know that you have a right to inspect your educational files. That includes your financial aid file, it includes your academic files, whatever files the school has on you, under the Family Educational Rights and Privacy Act. So the way you can get these documents is to go to your school and request to see them, or you can request a copy of them. If they won't give you a copy, at a minimum, you can request to inspect them and ask for a copy when you're doing so. You can make this request in writing. Usually there is a person identified, either a registrar or a records person, that you can direct your request to. If not, I would request it to your school's president, or somebody administrative that's high up enough to act on the FERPA request. Next slide. Another key document, so these are what some of these documents look like. So we have, for example, this is a sample enrollment agreement. You can see on it, which is super important, is how much the school has said it's going to charge you for the program. And that's very helpful in the future if you want to contest how much they actually charged you when you see your student ledger. Next document. And this is what a student ledger looks like. So this is typically how a school keeps track of all of the financial aid it's received on your behalf, all the credit, if you've paid cash, that'll be on here. And you can also see all the charges. So it's sort of a running list of everything that you are expected to pay, and also amounts that the school should pay you back if it got federal funds or GI Bill funds for living expenses, for example. Next document. And this is a sample master promissory note. So if you do get access to your files, another important document for you to get is all records of financial aid or anything paid on your behalf. So you'll see things like your master promissory note. This is for the federal loans. Next document. And this is what a private loan promissory note looks like. If you're confused, you can get a copy of both and look at the very top, and it will say if it's a federal promissory note. Otherwise, it will be private. Next slide. Other important things to do at this time: keep a diary documenting everything that happens. For example, if your teachers aren't showing up for class, if your online programs are low quality, if you're having trouble logging into your online programs, if you're getting told different things by different people at the school, all of that is really important to keep track of. It may matter later if you're trying to seek relief or seek debt relief of any kind on your federal student loans. Similarly, you should get your contact information for classmates and school faculty or staff who may later serve as witnesses. If your school closes or you have problems later on, all of these folks are going to have very important information that may help you and them get debt relief. So make sure you get your emails and your phone numbers and can contact each other. If you're having problems with your school and your school is again, approved by the Bureau for Private Post-Secondary Education, you can file a complaint. And it's extremely important right now to file complaints with the Bureau if you're having any kinds of issues. The Bureau is the oversight agency for for-profit schools, mostly. It needs to know if there are problems happening, and it won't know if it doesn't hear from people. That's the only way it can take action to rectify what's going on and help you. Now, if you're not at a Bureau for Private Post-Secondary Education school, you should file a complaint with the school itself, and you may also file a complaint with the school's accreditor. At least try doing that. If you're also having serious complaints with, for example, a private nonprofit, you can also file a complaint with the Attorney General's office. Finally, I think if you're having issues in this time, it's really important for you to share your concerns and what's happening with your state legislator, because they need to know what's going on in order to appropriately respond and help you. They don't know what's going on if they don't hear from you. That's the same with your federal legislators during this time. Your state senator, as well as your federal representative, they also need to hear, because they're the ones that are trying to put in place legislation that, again, helps you and helps students in this difficult time. So very important for you to share your stories or your concerns with them. Next slide. If you are having problems with your school or your online education, we really want to hear about it so that we can also help people like you in these difficult situations. So please feel free to contact us online or by phone. Again, as I said before, please file a complaint with the Bureau if you have a Bureau-approved school, and please share your experiences with your state and federal legislators. Next slide. So that's the end of our presentation. Does anyone have any additional questions?
Again, just a reminder at this time, if you have questions, please submit them via the chat box.
Oh, I do remember one question. Somebody asked about what happens if they're on a deferment while they are enrolled at school. The CARES Act doesn't impact any of those kinds of deferments. So if you're enrolled in school, you will continue with your school deferment, meaning you won't have to make payments while you're enrolled at school. Then once you stop attending school, you will have the usual 6-month grace period before you will be expected to start repaying your loans. Yes, we would be happy to send a copy of the presentation. What you have to do at the end is please provide your email address. In order to get MCLE credits, we will need your names and email addresses. I think Jay can provide information to you about how to do that. And I have a question. Another question is, if we see a lot of problems and issues in the future, how can pro bono attorneys help? It's difficult to find ways to get pro bono attorneys help. However, we may need help in the future if there are a lot of school closures with clinics, teaching clinics for students who are trying to get closed school discharges. And also there may be other opportunities, and we'll definitely stay in touch with our pro bono community to let you know if there are opportunities in which you can help us, because believe me, we have plenty of work. Now for the MCLE credits for the lawyers, please send your name and email on the chat room, and also provide your email if you'd like us to send you a copy of this presentation, including people who are on the phone.
Also, to address the pro bono question earlier, I'm including a link in the chat for folks if they would like to get involved or find opportunities to volunteer, not only in our student loan work, but in any of the other work that LAFLA does. I will be including that link. Or it might get lost in all of the
And the
messages
last,
going
there
on.
was a question I just saw. Where'd it go? Oh, the interest rate. Yes, the interest rate for people, well, so for people during the CARES Act, for all federally owned student loans, the interest rate is 0. Now, the question is, during deferment or grace period, is the interest rate 0? Yes, it should be 0, again, for the loans, the direct loans and the commercially held FFEL loans that are held by the department. It won't be the same, though, for all the other types of federal student loans. I guess we don't have any other questions.
There you go.
Oh, wait, here's one more. We don't do class action lawsuits, and I don't know, you know, the interest. Okay, so the question is what about a class action lawsuit to bring down the interest rate of 6.5% or whatever it is? First of all, we can't do class action lawsuits, but the problem is your interest rates are set by statute and by the promissory note that you sign. So those are what you're bound by. There's really no way for that interest rate that you're charged to be challenged legally, because it is set by statute, and it is set in the enrollment, in the document you sign when you get federal student loans. Okay, that's the last question. Sorry.
Okay, just a reminder, if you're here for MCLE credits, you should have already received your MCLE form when you registered. That should have been emailed to you. However, for auditing purposes, we do need to keep your name and email address on file, so please submit that via chat at this time. We will also be emailing to make sure everybody knows they can get a copy of the slides and recording of this presentation. We'd like to thank everybody for attending today. We'd like to thank our panelists, our presenters, and thank you so much, everyone. This concludes today's presentation.